is that cat?
Archer.
You're just gonna stare at me? Oh.
I am rollers. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Hope you guys are doing well. Hope you guys are having a nice Saturday. We are going to take a look at the Hillygus hearing. That was premiered yesterday. Was it yesterday? I think it was yesterday. It's about an hour, hour and 20 minutes long. So I figured because of the length, I can play some Battlebit. I'm still grinding in Battlebit to unlock the HK419 there. So we could watch that, and I'll play some Battlebit. Yeah. So if I hear some good bits, obviously I'll be making my thoughts known. But let's hope it's a good one. Though, from what I see in a little bit of the comments, it sounds like Hillygus has remained as unhinged as ever in his soft sit stuff. So. Uh-oh. Didn't mean to do that. Uh-oh. Hillygus is a soft sit who is accused of kidnapping his own mother from a nursing home in Nevada. They fled to California, where they were eventually hooked up.
Testimony about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Thank you. Mr. Falcone, welcome to Department 8. Please have a seat.
All rise. Second Judicial District Court, State of Nevada, is now in session. Honorable Mayor Guzzo presiding.
Thank you, everyone. Please be seated. All right, we're on the record in CR 19-1535A and B, State of Nevada versus Roger Hillygus and Stuart Canty, both of whom are in the courtroom. Mr. Hillygus is self-represented in custody. Mr. Canty's out of custody, represented at this point by Mr. Silverberg. The state is represented by Mr. Steggy. All right. Much to discuss today. I'm going to go over the court's list of things that I want to either address today if we get to it, but if not, the court is going to set a hearing a week from this Monday. The date of that would be Monday the 21st. Monday the 21st of August 9:30, which is 1 week before the trial begins. Now, next week, this court is not available. I'm here. I'll be working, but I start tomorrow picking a jury for the trial that's all next week, 15 count, category A, criminal justice case. That will take up the court's entire week with very little time to address anything else other than things that absolutely cannot wait. So we're going to discuss today things, and then we're going to have a hearing Monday. Indeed, the week before trial, we're going to have a second hearing on Wednesday, the 23rd. Why 2 hearings and why those 2 days? Those are the only 2 days that week the court's available. And in a moment, I'll go through the issues that I want to address at some point on those days. In a moment, we will turn to Mr. Silverberg's motion to withdraw. Mr. Silverberg cited to...
Wait, we're still on the motion to withdraw? I thought that's already, thought that already happened.
The Young versus State case. Because issues with respect to his relationship with Mr. Hanty will be...
Hey, Gojira, thank you for being a member.
When we get to that in a few moments, I'm going to have everybody leave the courtroom, because including the prosecutor and including Mr. Hillygus, because these communications will be closed. They're not open to public view. But before we do that, I want to go over the list of things that are going to take up our time today, Monday the 21st, Wednesday the 23rd, in advance of the Monday the 28th of August, beginning of the 2-week trial. Number 1, whether we're going to have an anonymous jury. The court has authority in certain cases to order that the information contained in the veneer questionnaires be redacted, to leave out the names of the veneer men and women, their date of birth other than the year they were born, their address other than the city and zip code, their phone numbers, things like that. So that neither the parties or anyone else interested in this case has an opportunity to know who those people are. Rather, they're just identified by their badge number. The hearing on whether the court will proceed that way is going to be Monday the 21st at 9:30 in the morning. So think about what your positions might be. Think about what points you might want to establish. Think about if you are in favor of that or against it. I will direct everyone's attention to a fairly recent case from the Nevada Supreme Court that spoke about that. It was a Department 4 case. Judge Steinheimer presiding. She was affirmed, I believe. Menendez Cordero, found at 135 Nevada 218. 135 Nevada 218 was a 2019 decision.
Oh yeah, Grixie.
Supreme Court. So look that over between now, please, and the 21st, and that can inform both sides, all 3 sides, on what the law is in Nevada. At that hearing, I'm also going to order that a representative from the Washoe County Sheriff's Office be here and be prepared to answer questions under oath with respect to issues that they have encountered, if any, with Mr. Hillygus.
Battlefield, Omega. Battlefield. Battlebit Remastered is basically if Roblox and Battlefield had a kid.
He's been in custody, or with Mr. Hanty while he was in custody. So, anonymous jury, court will decide that from the bench after the hearing, Monday, the 21st at 9:30. Now, whether it's an anonymous jury or not, Wednesday the 23rd, I'm directing everyone to come back to court. And the court will hand out to both sides a printed out version of the jury questionnaire packets. So all sides get them at the same time. If it's not an anonymous jury, well, you have the veneer men and women. You can research them like you do anyone else. Off you go. On the other hand, if they are identified only by badge number as a result of the court's ruling on Monday the 21st, then each side will get their redacted set at exactly the same time. Wednesday morning, that hearing also will be at 9:30. The cameras during the trial. Now, I realize the court indicated today we would address that. The court still intends to. I know people are here that may want to testify.
Uh-oh.
But it's likely the court does not make a decision today. It's likely the court will take evidence and argument today, and then, as furthered by anything that is decided on the issue of an anonymous jury on Monday the 21st, and then at that time as well, on the 21st, decide whether cameras will be allowed into the courtroom or not.
Come on, let him in. I'm fully, I think I've told you guys before, as much as I despise auditors and how they like to throw it away around in courtrooms, I'm actually in favor of more video access in courtroom hearings, like our Nevada judges is. And I feel like you could strike an appropriate balance between giving transparency and allowing the public to see court matters, and also protecting the potential privacy interests of witnesses. I think you, and the jurors, I think you can strike that balance. I mean, we've done it so many times. Come on.
If they are, of course, any media representative is bound by relevant restrictions on things like, I'm not patronizing, people understand in this profession what's allowed and not, but it just helps to remind us, if cameras are allowed, you never can pan on the jury.
Why would I?
Whether you would be allowed during the jury veneer process.
Why was I kicked?
Also,
I'm not hacking. Why was I kicked? That was rude.
so that's something that the court would have to consider in light of its decision, whether this would be an anonymous jury or not. That's why I really cannot decide that question today. Exhibit marking. So while you're here on Wednesday, the 23rd of August at 9:30, in addition to getting the jury veneer packets, you're also instructed to mark exhibits with the court clerk. And just to remind everyone, each side is able to mark proposed exhibits. Parties are encouraged to stipulate as to authenticity, if they're able to, admissibility, if they're able to, but if not, not. But they all have to be marked. Everyone gets a copy, so we have a list, and we can orderly identify which exhibits, audio files, video files, writings, text messages, interviews, if any, will be introduced at trial. So that all has to happen Wednesday, beginning at 9:30. Be prepared for that. I don't know if anybody is suffering from any physical limitations or disabilities. There has been at least one instance, maybe two, where one or the other defendants appeared in a wheelchair. I believe I've already indicated that.
Hillygus.
If either is intending to appear at court for any proceeding in front of the jury in a wheelchair, the court has to approve that and have some basis to allow a wheelchair in the courtroom. Some medical reason, some ADA reason that would be allowed. No one, if somebody shows up in a wheelchair and the court hasn't been made aware of it and approved it in advance, we're going to have a hearing outside the presence of the jury and have to decide whether that's allowed. But I can tell you that in the absence of a medically indicated reason, the court is not intending to allow.
Oh, please don't tell me this is what Hillygus is going to fight over. I really hope this isn't it.
The court intends to issue an order as soon as I can get to it, probably very early next week, during a break in the trial that I have starting, that there will be no use of cell phones in the courtroom whatsoever during the trial. During recesses, sure. Before, fine. Afterwards, probably fine. But no use of cell phone. Nobody who is going to watch this proceeding can be on their phone, speaking, texting, And of course, no taping the proceedings on a cell phone. Aside from the court ordering that right now, that's prohibited. Nevada Supreme Court Rule 229 prohibits it in the absence of court approval, which the court is not giving. So if anyone who's here now, or anybody who may come, or any counsel, or Mr. Hillygus has any communication with people that want to observe the trial, I mean, the courtroom's open. And I'm not taking the cell phones away. I'm not putting cell phones in one of those sealable bags. I'm not doing that. That's not this case. But no one's going to be on a cell phone during the court proceedings. It's inappropriate.
Yeah, no spoilers. I literally have not seen any of this yet, so no spoilers.
Disrespectful.
No, Thomas, this is running on a Unity engine, if you're that curious.
And the court doesn't allow that. And I want to make sure people understand, I'm not directing these comments to any particular individual associated with this case. This is the court's order in every case. This is the court's decorum order. I'm just reminding people, no use of cell phones during the trial. Okay, gallery. People are free to come in and watch the trial. They have to follow the rules and the attire, no shorts, no tank tops. That's not going to be an issue. But I can tell you, if we have for the seating the jury, the veneer process, there might be a lot of people in here. And if we run out of seats, and if you're not one of the people selected for jury service, you're going to have to either wait outside until we have more available seats, or maybe stand against the wall until we have a seat open. But if we run out of bandwidth here for people to sit down, first preference goes to the parties, their maybe immediate family, and to the veneer men and women. So not being disrespectful to anyone who wants to watch the proceedings, but they may have to wait outside until we have enough room. I'm going to address with Mr. Hillygus in a little while his courtroom attire. He doesn't presumably want to come to court for a trial wearing jail garb. He wants to be wearing clothes appropriate for the courtroom. So I'm going to have
I still can't get over the fact that Brooks fought to keep wearing his prison jumpsuit, thinking that that's going to make him look sympathetic to the jury.
ask him whether he's anticipated that and what his plan is. I realize it's restrictive. He's told the court repeatedly he's not domiciled in the Republic of Texas, and so I don't know if he is.
Wait, is he actually say he's a member of the Republic of Texas? Okay, that actually maybe I knew that beforehand, but that does explain a lot.
Professional clothes to wear to court or not, what his plan is, but I want to make sure that he has the opportunity to be dressed appropriately for court. Mr. Yante's ankle monitor, I want to talk about that. I'm prepared
That's
to
possible, Josh.
consider, we'll have the discussion on this on Monday or Wednesday of the week before trial, where it can be removed during trial. I don't want him to, A, be thinking about it, and B, I don't want the jury to see him having that on and any negative connotations that go with that. I have another trial coming up where I have a similar situation, and what we ordered in that trial, that the accused go to sober 24 in the morning, right before court. They take it off, and then he's in court during the proceedings, like Mr. Hanty, out of custody, and then when court is over, he goes back down there. I've given thought to possibly allowing Mr. Hanty to have that removed the Monday before trial, keep it off the whole week, and then put it back on Friday afternoon. And so my mind isn't completely made up on the everyday option as opposed to the weekly option, and then have it back on for the weekend. So think about what your position will be as to that. But I recognize that Mr. Hanty has been displeased with the court's decisions on having him wear that over his objection, and I want to make sure it doesn't work to his disadvantage in any way during the trial. Order will come out shortly about courtroom decorum. Don't talk over the court, don't argue with the court, argue to the court.
Oh boy, that's going to be a rule that's going to be broken. Yes, the Republic of Texas is still alive. It actually is.
To Mr. Hillygus, I will remind him shortly I'll do now, that his argument that the court lacks jurisdiction has been made.
There it is.
Repeatedly through these proceedings. It's preserved.
Ad nauseum.
You do not, Mr. Hillygus, need to reaffirm that every time to make sure that your position is known, understood, and preserved for any appellate review, if there's going to be any. So the court would deem further statements to that effect, or reminders of your view of the court's lack of jurisdiction, to be improper and potentially contemptuous. So, I'm likely, if it comes up from this point forward, to give you one further warning. After that, there will be consequences. I don't want that. I don't think you want that. Your position is known, and it's preserved for the record. Second.
Oh, by the way, guys, I'm also currently live on Twitch for the first time in like ages. So, yeah.
Trial week, beginning Monday, August 28th. And we start at 9. Courtroom will be unlocked and ready to go by 8:30 to set up. Let's actually, now that I think of it, let's go back to
Hello,
the
Jester.
before trial, when you're getting the jury veneers, either redacted or not, and you're also going to mark exhibits. The court directs that if the state intends to have a technologist here to help set up over an Elmo or screen or something to play audio or video or show exhibits, that not only does it need to be set up, but how it can be used either needs to be explained to defense counsel or defendants if there is no defense counsel, so that they can use it. Or alternatively, during the trial, if they need to use it and they can't grasp it, then Mr. Stady, the court would direct you. I know you're professional and would do this anyway, but would help them out. They want to show exhibit 2, you help them put it up there, things like that. But Wednesday before, we're going to check out how these monitors work and how they can be used. So that's really the third thing for that Wednesday. Jury questionnaires, mark exhibits, and technology in the courtroom.
Hey, Rivy Sticks, I see you in the Twitch chat, which I finally have like right in front of me to make sure I don't miss people talking in Twitch chat.
Mr. Handy has previously filed.
It's not a problem I've always had.
Something else, or okay. Mr. Handy's previously filed a motion to change venue. The argument being that with pretrial publicity, he's concerned he might not have the opportunity to have a fair trial. The court, consistent with Nevada law, has said that it's holding that determination, the expression, in abeyance. It's on pause. The court will address that if asked to, again, after the jury selection process, after the voir dire, I should say, process. If the
Voir dire?
believes,
You mean voir dire?
believes that they cannot get a fair trial based on the manner in which the jury questioning process went, they can ask the court for a hearing on that. We'll take it up and the court will make a decision whether to transfer this case to another jurisdiction. The court reminds both sides that there's legal authority on that needs to be followed, showing that needs to be made, who has the burden of making that showing, and also that the pretrial publicity is not a product of their own doing. Because even if there is pretrial publicity that could affect the case, the court has to determine from what cause or source, if it's able to. So that's still out there, if and when. And then, of course, we are set today for the so-called motion to confirm, which really is a question to both sides, all things being resolved here on attorneys, exhibit marking, things like that. Are we ready to go? Is there any illegal impediment, things beyond your control impediment, family emergency, other trial that ran long? I mean, things like that that you can't anticipate and cannot handle. If there's something like that, the court in such a case has postponed a trial for a few weeks to let whatever was going on get wrapped up. If we just want to postpone it because we want to postpone it, that doesn't carry any weight. All right. I may have overlooked something, but those are the issues the court wants to address today, Monday, the week before trial, the 21st, Wednesday, the 23rd. In a moment, I'm going to excuse everybody and talk to Mr. Silverberg and Mr. Handy. But before I do that, Mr. Stiggy, any comments or questions about anything the court just said?
No, I would, on the Young matter, I may have something to say about that before I'm excused. I wonder, I know there are people here on the media matter. Does the court want to handle that so they can?
I don't, because I don't know if Mr. Silverberg is going to be here as an advocate for Mr. Handy on that issue or not.
Okay.
So I really, with all respect to people that have marked this time out of their day to be here and be heard, I need to handle this other issue first. And if I'm understanding from prior matters, your position on this might be that the prosecutor shouldn't necessarily be.
Randy, what's up, man?
From a hearing.
I know, I need to put more emotes on the,
Right, not in all instances, and of course, the state has
on the Twitch.
voice.
Twitch still has the better emotes, true.
Okay, well, the state will have an opportunity to be heard if we get to that point, because I want to make sure I understand, this is a motion to withdraw that Mr. Silverberg filed and is seeking a Young hearing. This is not Mr. Hanty seeking a Ferretta hearing for the ability to represent himself. That's a different hearing. So it's, the court intends to review, consistent with Young versus State, what the nature of the dispute is, whether the relationship is so fractured and how come, and take into account other things like the procedural posture of the case, how soon the trial is, and other matters. So that's what I have to say. But with respect to the court's laundry list of issues that need to be addressed, nothing further.
No, thank you.
Okay, Mr. Silverberg.
No, Your Honor.
All right, thank you. Mr. Hillygus.
I do want to make a statement that I do not consent to contract with this.
There it is. And here we go, boys. The moment we've all been waiting for.
Questions, are all men created equal?
Oh my God.
That no man is above the law?
Oh my
Are
God.
you above the law?
Oh my God. Why are you stacking questions? You've asked now 3 questions. 3 or 4 questions now.
Follow judges' orders?
Ah.
Court of law?
See,
Do you follow the
I should have put a counter. What are we at? Question 6? We're at 6. We're gonna say he's had 6. questions now.
Mr. Hillygus,
cited in
Mr.
chapter
Hillygus, this is going to be an
one
example.
of
It's
7.
going to be an example of me asking you to please
Stop.
down on this, because this is not responsive to the court's questions.
Is the common law cited in NRS, and do you
8.
follow the common law?
Mr. Hillygus, this
9.
is going to be the last warning that I'm going to remove you from this courtroom on a very important matters. You're going to step outside anyway, so I can talk
Oh, God.
to Mr. Silverberg. But right now, I want you to focus on the issues I just raised. Those are I want to make sure you heard what I said. You realize those are issues I want to go over.
I didn't challenge jurisdiction, but I just want you to know that there is a judgment, a 3-judge judgment that's.
3 justices.
3 judges have issued a judgment against you.
He's probably thinking they're probably justices of the Republic of Texas, which is probably 3 random goobers who appointed themselves as justices. And her LARPing federation. Of course they did.
I just corrected you. There are 3 justices. I've read it. And it's been filed in.
That was in the private, that was sent to you through the private.
It has no,
Put it into the public.
it has no legal effect on what we're doing here right now.
Allegations that have been remained silent. So you consented to the contract. There's criminal allegations.
How did he consent?
A grand jury indictment.
What?
You cannot proceed.
Again, a grand jury indictment from members of the Republic of Texas LARPing Federation.
You've got a conflict of interest. You've got a judgment against you. And so this case shall be dismissed because I'm not committed.
It shall be dismissed forthwith. And the judge's like, okay, anything else from defense counsel? All right. Yeah, you're going back to jail pending the rest of the hearing. Have a nice day. But this has been dismissed. Sure, Jan.
Crime. I mean, against my free will.
Well, yeah.
Multiple Fourth Amendment violations that have been committed against me, and I can raise those and explain them to you.
Well, we're
But
not
I
here.
was
Okay,
arrested
Mr.
in
Hillygus, Mr. Hillygus,
California
Mr. Hillygus, that's
without
enough.
a warrant.
I
I was
understand.
arrested in Missouri
Mr. Hillygus,
without a warrant.
this is the final warrant. These are a warning. You made these points before. And the fact that there's a new judgment by 3 justices against the court, and I realize that's something that.
Well, it's more than just the court. It's that there's quite a few defendants
So
and
you-
respondents.
So earlier when I said that your challenge to the court's jurisdiction has been noted and made of record.
Duly noted and ignored.
Judge, this is some new information, new situation. I want to make sure everyone's aware. This is not the time or the place. If you
Nope.
believe that there's a legal basis for this case not to go forward in light of something that's happened somewhere else, you have to file a motion, let the state respond, I will consider. But right now, we're focused on these pretrial matters.
Is he a classic soft sit or an American national? That's actually a good question. Because it does feel like American nationals are becoming their own breed, their own, like, I don't want to say subspecies, but yeah, of sovereign citizen. I think he would say he's an American national because the Republic of Texas leans heavily on American national, because most of the time they say that they're not a citizen of the United States, they're a citizen of the Republic of Idaho or the Republic of California, that type of thing. So I would say he's probably more so an American national than your bog standard soft sit.
As one of the people, I do not file motions. I call for a court of record under the common law. Is this a court of record under the common law?
Okay, I understand your position. So here's what we're going to do. I'm going to ask everyone to please step outside. I'm going to have a closed hearing where I'm going to discuss with Mr. Silverberg and Mr. Ante the nature of their relationship, and then I will have the deputy let people know when they're able to come back in. For those that are recording these proceedings, make sure please the camera is off and the camera operator steps outside as well.
Aw.
Mr. Hillygus, I'm going to ask you to, also the deputies to escort you outside of this.
Judge, sounds like always clear.
It's clear. Okay, we'll go back on the record. For those that have previously requested permission to record these proceedings, they may begin recording again if they so choose. The court has held a hearing pursuant to Young versus State and determined to deny the request for Mr. Silverberg to withdraw. Mr. Silverberg remains appointed counsel.
Oh, they denied his request.
Mr. Ante trial goes forward. Next, pursuant to Nevada Supreme Court Rule 230, the court is aware that there is a presumption that courtroom proceedings are open to the public and are subject to electronic coverage.
Which is, I believe, is how it should be. But I know that they're challenged. I actually got to ask Alex if that challenge to the new rules are is still happening. Though I think that's for family court. This is for criminal court. I think the challenge to the rule is family court, the family court restriction. But yeah, that's how it should be. There should the way I see it is that there is a presumption of access. And so, like, upon written, like, notification, like, you know, our Nevada judges intends on recording these proceedings, there's a presumption of approval unless the judge in written form can write the reasons why they should not be recorded. And the judge has to make that burden in writing, in my opinion.
In the event that the court determines that that should not be allowed or should be limited substantively, the court is generally directed to consider factors such as the impact of coverage upon the right of any party or witness, the impact of coverage upon the safety and well-being of any party, witness, or juror, the likelihood that coverage would distract participants or would detract from the dignity of the proceedings, the adequacy of the physical facilities to allow such electronic coverage, and then, of course, the catch-all, any other factor which would impact the fair administration of justice. Now,
I would say the involvement of minors could be a factor, but the fact that minors are involved to me wouldn't be an all you needed to restrict access, in my opinion, because there are ways, there could be easily ways of protecting a minor's privacy during a hearing. Why was I kicked again? This is BS.
we have counsel here, Mr. Busby, I think you're here on behalf of our Nevada judges.
I am, Your Honor.
All right, feel free to come forward. I'm gonna, just because there's an empty seat here, you know, have a dog in this underlying fight, you're here to talk about access to.
Why?
If you would please take the chair available there. And would you, again, just state your name for the record, spell your last name, and tell us who you represent.
Yes, Your Honor, Luke Busby, B-U-S-B-Y, farm 1319, here representing our Nevada judges.
Very good. And then I understand that Mr. Conrad from, this is Reno, has an interest in electronic coverage of these proceedings. Are you here, Mr. Conrad?
Yes, sir.
Mr. Conrad, Dr. Conrad,
Yes, sir.
Ooh.
nice to see you. Do you have a
Doctor.
pending request to coverage this electronically by video? If you do, have you talked to our Nevada judges about access to the common feed, anything? Or tell me exactly what you would ask the court to do today with respect to your comment.
So typically we do a full video, and if our Nevada judges is good with doing the video, we would just request audio and photographic access.
Okay. Let me.
I'm going to watch the game today? Probably not. I mean, it's not going to be televised on my end.
Let me ask this question. Is it something you want me to order? Do you want to have time to talk to Mr. Busby? Or if you have a legal representative, talk to Mr. Busby? Do you want to monitor the hearings? Do you want to be put under oath and explain that if you're allowed to be involved at the trial, that you'll abide by all proper procedures, not video or in any way interfere with the administration of justice? I mean, things like that? Or what do you want to do?
I guess I would just request access, either photographic and audio access, and whatever I need to do that. I believe I filed a request to cover this hearing today, and I'm happy to file a similar one. For
Okay, and did we grant the request for today?
I don't believe I ever got a response.
Okay. Well, I've
well.
allowed our Nevada judges, they've been here for multiple hearings. They're familiar with the rules that apply to this type of a proceeding, the limitations. They've been, as far as I can tell, professional in the manner in which they've conducted themselves. What I would suggest.
There's another key thing that the judge said right there. So attention to auditors, professionalism. If you go in, make a request, and act very professional about it, you're going to be treated a lot better than if you just blast your way in, cameras rolling, and then get all huffy when they don't want to give you the time of day. But anyway.
Is this to collaborate during a break with Mr. Busby and or his client and talk about a way that you can collaborate. If you asking me to grant permission to you and your company, I would need you to certify you're familiar with our local rules, you agree to follow them, generally we require one feed and everyone to work together to figure out how to use that collaboratively. We don't have two cameras in at the same time, if that makes sense to you.
It does make sense. The hearings that I've covered prior to this one, typically, again, it's one video feed, and then there's sometimes a photographer separately because still images. And
To get a still photo?
yes, sir.
And again, we're talking about this hearing, maybe Monday, next Monday, and then maybe the next Wednesday, and then of course the trial, right?
I don't know my schedule off the top of my head about what all I will be covering in the future. I would like access to the trial, so when I get that in front of me, I'm happy to file that request with the court.
So for today, you'd say you'd like me to order that you can do that which you requested previously, but we didn't get back to you?
Yes, Your Honor.
Are you aware of the request, Mr. Stakey?
No, but I'm aware the rule requires the parties to be notified of it. Reading the rule here, it does allow, pooling anticipates no more than one television camera and one still photographer. But because of the notice requirement, I asked the court not to rule on that, but to require, this, agency, just like any other agency, to conform with the rules.
Well, you heard Mr. Conrad say that they made a request and either the court overlooked it or we meant to communicate back and it didn't happen timely. But, so I don't want him to be shortchanged today if he otherwise would have been allowed to.
Well, right, but again, we have notice and an opportunity to be heard for
I
a reason.
understand.
If he does not comply with that, or if the court doesn't, that does not, I think.
Shouldn't impact you.
No.
I got it. Mr. Silver, do you have a position with respect to this is Reno?
Your Honor, we don't object to any of the requested coverage.
Okay, thank you. So, Mr. Conrad, here's a little bit of a pickle the court's in. For reasons I don't know as I sit here, we didn't timely communicate the request to both sides. And so they didn't have a chance to decide what their position would be, such that the court could weigh that factor in whether to allow This is Reno to report video or still. So the request, to the extent you're renewing it now in open court, is denied. And that's, if you want to be upset with how we handle this, be upset with me, not with any of the parties here. For some reason, we overlooked that. I don't know why it wasn't communicated to you, but I can tell you that.
Well, that's rude.
You submit another request to us, email. I'm not sure if there's a form now that the Second Judicial District Court is using.
Yeah, I agree.
Or rather, it's an email to the court administrator, Alicia LaRue, but she's been forwarding them to the departments promptly, and we turn it around rather quickly. So if you want to be here for Monday, the 21st, or Wednesday, the 23rd, get those to the court quickly, and then on Monday, the 21st, I'm going to make decisions with respect to whether cameras will be allowed in the courtroom for the trial. You understand?
I do understand, and without due respect, I did file this a couple weeks ago. I sent it exactly to your point to the court administrator.
Yeah, I'm kind of.
Receipt. And so I believe I've done what's.
I don't know what happened.
I think they're giving this reporter the shaft, in my opinion. How is it his fault that somebody in the court messed up? I'm kind of, well, it's not even the camera. It's him as a it's for photography and audio. I'm calling.
I can tell you this, not to justify if we overlooked it, but to give context. I just finished a nearly 2-week murder trial, and your request may have came in during the middle of that, and I may have just overlooked it. So I cannot prejudice the state's rights or the defendant's rights, so I'm going to have to politely but firmly say I can't let you record or take stills from today's hearing because I haven't approved it after input from the state. I will assure you, however, if you make a request going forward, the court will give it immediate attention and respond promptly. That's the best I can do, Dr. Conrad. Thank you. Let's move forward.
Boo.
Motion.
Boo.
Beg your pardon. Mr. Busby.
Thank you.
All right, do you want to make argument? Do you want to call a witness? Do you want our judges to somebody to testify and how familiar they are with the rules and agree to follow them? I see it looks like your client representative is here, the principal. If you want the court to hear from him, you can call him as a witness, and I'll certainly consider whatever he has. Of course, both Mr. Steggy, Mr. Silverberg, and Mr. Hillygus can ask questions.
Right on, Michael.
Yeah, Your Honor, I think that's appropriate in circumstances.
Sure.
I'd like to initially call Mr. Halligan about penalties.
Okay, sure. Please come forward.
Do solemnly swear or affirm testimony about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Oh no! Is that the man? Is that the man of the hour? Ooh! He's taking the stand. He's under oath.
Mr. Falcone, please make yourself.
Alex, Pog,
Take the microphone.
everybody Pog in chat.
And you can even add another blue book underneath the microphone if there's one up there, if it's not high enough for you. Should be good.
Oh my God.
All right, when you're ready, please tell us your name and spell your last name.
Alexander Falcone, F as in Frank, A-L-C-O, N as in Nancy, I.
Thank you very much. You may proceed.
Use the darn emote if you're a member.
For the court, Arnavata Judges, what it does.
Arnavata Judges is a non-profit corporation recognized by the IRS as a 501c.
I have a Pog emote, you fools.
Electronic coverage of judicial.
You darn boomers. Hey, Brad.
Proceedings have you provided?
They're taking testimony as to on whether or not camera's going to be allowed for the trial, and so Falcone, well, obviously he's going to want to have media coverage. He's taking testimony as to his knowledge of the court rules and yada yada yada, in order to allow them to allow the court to approve media access. That's why he's testifying.
Since,
We have published over 600 hearings.
are those hearings exclusively in Nevada,
Yes,
in state court?
yes,
Okay. Have you ever had any complaints against you?
no,
Have you ever had any allegations of misconduct issues related to your coverage?
none that were sustained by the court.
Okay. How many jury trials has Nevada Judges covered?
5.
And do you understand?
The emote is literally called Pog, Josh.
CR 230 for the scope of coverage?
I do.
Can you describe for the court very briefly your ground rules for providing coverage at jury trial?
We provide
It's-
comprehensive coverage.
It's Archer with a shocked face. Oh my God, I have a boomer community. I really do.
From beginning to end, and we do not record the jury.
Okay. And can you explain to the court why Nevada Judges would like to record this proceeding in particular?
This particular proceeding is one of our high interest cases. Part of it is because of the guardianship issues that are being discussed in the case and the history of this state with guardianship scandals in the past. And the other part of it is there is national attention on guardianship because of the Britney Spears issue. Then there's also issues of public interest, of the special public interest in, I don't want to use labels, but the manner in which the defendants are defending themselves. There's labels out there, and there is public interest generated in that specific type of format.
Will your coverage have any bearing on any right of a party to receive a fair trial in this matter?
It hasn't before, and I don't anticipate it'll happen now.
Will your impact coverage impact anybody's right to privacy and party or witness?
No. In fact, when sensitive personal identifying information is mentioned, we redact it.
Including, excuse me, to ask a question, Mr. Buckland. So if a witness takes a stand and they say, they're asked their name and they tell us, do you redact that part?
We could if you'd like to, but what I would say is like where they live, phone numbers. We don't want the public to contact them, send them emails and letters and stuff like that. We could redact the name too if they would request that. The only time I would be hesitant to do so is if the witness were a public figure, perhaps a government, like a police officer or something like that. And there would be, of course, exceptions for them if they're in particularly dangerous lines of work, like undercover operations and stuff like that.
Okay.
There are always exceptions, but generally, we want to provide the public the information and the educational value of the manner in which this department and this district conducts itself without interfering with the trial process, without causing...
I keep forgetting that a lot of you guys watch on the phone and not on desktop. The emotes look larger to me because I usually see chat on my desktop. So, anyway. Yeah, alright, fine. All y'all, whatever. Thank you for the raid, K-Far.
One or two more questions, and I'll turn it back to you, Mr. Busby. Have any of the 5, did you say you've done 5 jury trials so far?
5 jury trials.
Have any involved a self-represented person or persons?
Yes, and that one was particularly difficult for District Court Judge Michelle Levitt for a long time.
Oh, we talk about Blandino?
But in the end, it went to completion. There was a verdict. I understand that those cases are particularly difficult, and I have certain things that I do. For example, I am very hesitant to cover them live when it involves a pro se litigant. And if there are direct camera antics, I will edit them out because I'm concerned about, the camera is supposed to be a fly on the wall. So when litigants look directly at the camera and are drawing their attention away from you and the attorneys, that's something that
That's what we want to avoid. That's the whole idea of why the court sometimes exercises discretion. They think that that's going to change the way people would act.
One of the things that's difficult is sometimes the litigants don't want coverage, and to create a situation where a litigant could misbehave just to thwart media coverage and camera access, in my opinion, that's also problematic. I think
which is also true. That is kind of these things that we have to think about and how we have to consider when it comes to courtroom access, because he's right. People can and do, you know, kind of change their behavior and change how they look, even though the court hearing itself, the transcripts are there. People tend to. It wouldn't surprise me if there's solid research showing that people tend to act a little bit differently when they see a camera in front of them. There's no doubt in my mind that is a thing that happens, and it could possibly affect the integrity of the trial. Could. I'm not saying it will, but could. And I think that's a fair factor to consider. That being said, I'm still erring on the side of permitting access. But I also understand where Alex is coming from, is that a defendant or a party is acting a certain way with the intention of restricting courtroom access. Daryl Brooks for certainly comes to mind in that regard. Yeah.
a lot of this comes down to trust.
I'm not really concerned with any of that in this case, where somebody would act out to interfere with the ability to cover.
Right.
But by the same token, though, sometimes people will act differently because they are encouraging, or because they know that this is being recorded or will be published. And that I want to avoid too.
Right, and there's a certain level of trust that comes from the different roles that we serve. And I would hope that our track record with other very typical cases is not the first typical case, but I will concede it is one of the ones that's towards the top. There's a certain element of trust there in what we're going to publish and what we're going to encourage and discourage, because I'm very mindful of that. Even sometimes, I mean, I've had a situation where an attorney...
He didn't get arraigned because he was causing issues in jail? Oh my God.
Well, that would be...
What were his warrants? What did he have warrants on?
Are you asking to live feed this?
Failure to pay child support?
This is not slated for live coverage.
Okay, fair enough. Please continue.
Thank you, Aaron. And Mr. Beckham, continuing on elements under Rule 230, will your coverage have an impact on the safety and well-being of any party?
Can I ask you to speak up? You're a very soft-spoken man, which is good for life, but sometimes you can, if you
Fire license times 2
on the table, you should be able to hear you.
Do you mind if I sit down?
I don't mind at all. Thank you for asking.
That should help. Mr. Falcone, will your coverage have an impact on the safety and well-being of any party, witness, or juror?
No, and if any of the attorneys have concerns about a particular witness, please let me know and I can keep the camera back or off of that particular witness if they have anxiety or something like that. So I'm very mindful of the fact that the camera could impact testimony, and I will do what's necessary for a particular witness to make sure they feel comfortable. Just as I mentioned before, I'm just hesitant when it's a public figure or somebody who works for the government who's on a salary. I can still do that.
Which I agree. Which I tend to agree. Also, I think if you're generally a public figure, you don't have that sort of level of privacy. You don't have no privacy, which again, freaking BS. Auditors and how they act, but you don't have no privacy, but you have less privacy. Randy, thank you for the 100 bits. Oh my God, do I even have alerts turned back on? I don't even know if I have alerts turned back on for Twitch. I have to turn back them on, so I didn't get an alert for the 100 bits. But thank you, Randy, for that.
But then the public doesn't notice, and it does sometimes trouble the public.
Okay. Also, sorry.
Wait. Wait, 500 bits. You gave me 500 bits. Thank you. It says 100. It says 100 bits on the alert.
You heard, and probably for the first time, everyone may have heard that the court is considering impaneling an anonymous jury. So, in the other trials you've done, Mr. Falcone, have you taped as well the jury selection process?
No, someday I would like to, but I do not intend to do that for this.
1, 2, 3, 4.
Whether it's an
Oh.
Anonymous jury or not,
It's-
it's the same response.
Yeah, it's 100 bits 5 times. Okay, shut up. I hate you all. Leave me alone.
Thank you, Robert.
I'm not a Twitch streamer, okay?
Address the issue of whether your coverage would distract participants or distract from the dignity of the proceedings. Is there anything else you'd like to describe for the court about your procedures when you're actually filming that may allay its concerns about whether your coverage would be disrupted in this case?
I'm very emphatic about our fly-on-the-wall policy, is that we're to be noticed as little as possible. And to the extent that the court has any concerns whatsoever, paramount for the Nevada Judges Corporation is to cover the trial, but there are things that we can do to alleviate.
I'm not an e-girl, okay? Chill.
So let's say something happens during the trial that I have concern about. How do I get your attention, Mr. Busby's attention, or the camera operator's attention? What's the procedure there that you would suggest?
Well, first of all, for this specific trial, I do intend to personally supervise the
Okay,
recording.
as in be here for the whole trial or most of the trial?
The only exception is one day when I need to record District Court Judge Sandra Unsworth, and that's the only day, which would be a portion of Friday.
Okay.
And
But the other times you would generally plan to be here?
I will be here, and you'll have his contact information in mine, admin@ournevadajudges.com. I don't mind if the public has that.
So if an issue came up, we'd go right to the big guy here.
Yeah, I want to educate and inform without interfering with what you're doing. That you're doing very important work, and I hope that you understand that we're just trying to teach the people without getting in your way.
Understood. Thank you. Please continue.
Thank you, Your Honor. Mr. Falcone, are there any issues with the adequacy of the physical
I noticed that too, Josh.
proceeding?
None whatsoever.
He already
Is
called
there
me
any
out
factor
for my
where Nevada judges might do something that would interfere
for my
with
GoFundMe.
justice in this case?
I would, under no circumstances would I allow that to occur.
Thank you, Your Honor. I have no further questions for the witness, and we respectfully ask that Mr. Falcone's request to be granted.
Okay. Thank you. One more question, Mr. Falcone. And then I'm going to ask Mr. Stakey if he has some questions for you. Then I'll ask Mr. Silverberg, and I'll ask Mr. Hillygus. You were here, or I think you were aware, because I'm remembering a communication, I think from our Nevada judges afterwards, where Mr. Hillygus stood up and ripped something up, and I think playing to the camera or directing it to the camera. And afterwards, I seem to remember a communication from our Nevada judges indicating that no intention of including that in its online available transcript of the hearing.
Correct.
Do I have that right?
Yes, you have that correct. There was a portion where the paper was torn and you turned, edited out was the portion where you turned and looked at the camera. It's difficult because we do want the public to see what's occurring. So I tend to not want to remove something that's recognizing that allows the public to see the difficulties that the court is actually going through. But the portion where he turned and looked at the camera was edited out. Was it a concern to you that the torn up portion was still in the footage? Because that's something that we can, it's tough. These cases are tough. These cases are tough. It's not the only one.
Well, you've impressed upon the court that you're trying to do the right thing. That's really the one of the court's considerations. Mr. Stakey, any questions for Mr. Falcone?
Yes, please.
Go right ahead.
What is the scope of your viewership as it relates to this case? Or size?
Yeah, I tried, and people in my mods could confirm this. I tried my best to be as charitable and as forgiving as I could with Granite, because I didn't want there to be a complete echo chamber in the Discord. I really didn't, but he just kept on pushing the line over and over and over and over again until I can't. No, I'd stop it. You're out.
Would you like the analytics? I have them on my phone.
Or maybe you could speak of that in general terms.
In general terms.
Hold on one second. So I want to make sure you're asking a question that informs the court, but also we're not asking for, it's not, you can't ask a rancher generally how many head of cattle do you own, because that's like asking somebody how much money you have in the bank. So if it's a sensitive, business or interest or financial, let us know, and
It's not, I don't
It's
mind.
not, you don't mind, okay.
Well, and YouTube analytics are generally viewable to the public, correct?
They're not, but it's okay, I share mine, so don't worry about it. So views, we have about 2.5 million, watch time minutes, we have about 33 million watch time minutes, just count.
Ooh. All right. Alex is now flexing his YouTube channel.
Facebook's analytics are a lot more convoluted. I would guess it's an additional somewhere 20%. The demographics are what's interesting. They're not youth that are watching them.
No, Ardo, Granite is more than likely from New Hampshire, aka from the Granite State.
They're, from what I can see, academics, people who are busy, they have jobs, they are interested in the court system, they would observe the court proceedings if they could. Unfortunately, they just don't have the time to. And we're talking, my biggest demographic is 55 plus, second biggest is 65 plus. So the people who are watching the videos are people who I believe have very busy schedules, full-time jobs, are earning salaries, and are interested in the operation of our courts. Most of it is Nevada, with a very small percentage of it being the rest of the country and other countries. In fact, this state is actually impressing upon countries like Greece, the United Kingdom, Ireland, Australia. You're actually having quite an effect on the rest of the world by allowing people to see comprehensively the proceeding. We have a very unique format. I don't know if you're aware, but we've been covering this case since 2019, every single hearing. And what it does is it allows viewers to sort of learn, instead of just, here's a small little bubble of time of what happens in court, the context throughout the years of what's going on. Interestingly enough, any court can thwart camera access, but it really can't thwart discussion of a case. And what the camera seems to be doing is causing the viewers to get a very accurate picture of what's actually going on in the case. And overwhelmingly, the public appears to support, generally, the judiciary. I'm not giving specifics about this case because that's not my intention to do that.
Well, and the intention of my question is, across your platform, this case in particular, I think you said it's your most.
See you later, Tones.
It's neck and neck with two of our other cases. They're very close to the top.
And so if the court were to think about, well, what impact on the community this would have, what is your estimate?
It would piss everybody off if you court access. That's what he's alluding to. If this judge denies court access to the actual trial and blue balls us after watching this madness, oh my God, there's gonna be rioting.
Estimate of the number of people your coverage would reach in, let's say, the state of Nevada.
Oh, I would like to say that most of the citizens watch our Nevada judges. I would be surprised if it was between 5 and 10%. We're not large enough yet. Yeah.
You did mention, and for the purposes of sort of the court's consideration, that there would be a delay. This is not a live feed.
This will not be a live feed. And if you're concerned about the exclusionary rule, I could delay publication until after the verdict. The public will probably be somewhat upset about that, but it should.
Yes, we would.
Well, my question is, what delay did you come to this hearing anticipating?
It's actually a delay of just the fact of how long it takes us to edit. So it's kind of self-imposed. Usually we can get, say we do a full day, you might see part one the next day, which is like 2 hours of the day prior. So there's, beyond the first and second day, there's just gonna be a delay because of editing.
And that brings me to my next question. You have mentioned the ability to, and your own desire to edit portions of the proceedings. I want to ask you how long that takes, or how much do you, say the last court hearing, how much did you have to edit?
It's about, I could say a rule of thumb would be 2 hours of editing for every 1 hour of footage, and that's only because it's me personally handling it. If somebody else does it, it's even slower.
Okay. And so you were asked by your attorney what, basically your opinion on the impact on the jury, but you don't really know the jury's ability or the veneer's ability to go onto your website during trial.
Right. We haven't had any issues in the past.
Rule of thumb.
There was one sort of odd issue with the very first jury trial, if you'd like me to go into and explain.
Please.
So with the first jury trial, there was...
Warzone 2, Randy? No.
Statements were covered, and...
No chance.
It wasn't a juror, it was one of the witnesses for the state, saw the opening statements, contacted the prosecutor about some new piece of evidence they had, and then they provided that new piece of evidence to the state. I do recall District Court Judge Christina Silva mentioning that it wasn't a problem with the media so much as a problem with a new piece of evidence being provided, and if the state was going to insist on using it, they would have to schedule a new trial date. That, of all the situations, that's the only thing that's ever happened.
And is that the most sort of serious sort of, not conflict, but issue you've had involving trials?
Yeah, that's it, you know. And it's tough because we didn't do anything wrong, but arguably, if the camera wasn't set there, the witness would have never seen it, would have never sent anything to the state.
And although I am not suggesting this, but you are willing, if asked to, delaying publication until after the verdict, or some number of days delay in publishing what happens?
Absolutely. Paramount to the organization is to provide comprehensive coverage of the trial. If that's something that we have to do, then we will do that.
And you're asked by your attorney about sort of the risk of danger to the public or witnesses or anything like that. That's, you don't really know anything about that, right? Like, you're not in law enforcement, you haven't done a sort of threat analysis in the case, correct?
Well, we have a good relationship with the prosecutors in Clark County. Just let us know and we'll take care of that.
Well, and what I want to touch on is you're of course aware of, like, there's been various threats made against public officials within this case by people interested in the case.
I am aware of that.
Okay, and you would agree with me that that could be amplified given the coverage?
I wouldn't say so, because the problem is the information. So even if camera access is denied, the information is still going to be available by whoever's observing. Typically, because misconduct in these cases is connected very closely to the parties, removal of the camera, even sealing and redaction, often doesn't do much. My biggest concern is preventing harassment. So that's why the most important thing is the emails, phone numbers, stuff like that.
And you yourself have been party to, or not party to, the subject of or received some of the various harassing emails that have been sent out.
And that's also relatively normal. The most important thing, hopefully, is to judge me by what I publish and not so much the communications that I receive.
And I'm not suggesting that, but I'm asking you to reflect on, this case has a feature that there are people out there in who knows where who are sending emails to a lot of people in the case, including yourself, sort of harassment being the main goal.
Well, he already acknowledged that that's the case.
Right. And so, do you have thoughts on how your coverage may or may not contribute to that harassment factor? I point out to you the flyers comparing this court to Nazis, calling people associated with the case baby killers.
Well, to be quite...
Oh my God.
The camera, those things are true, and I've seen those things. And the counter narrative provided by the camera is that when you thwart a third party from providing electronic coverage, that stuff is still being published. There's no way to stop that. All we can do is publish the truth.
And so you see your coverage as really being counter to some of those narratives?
You could say that, but I mean, it's not really our objective. The purpose of the camera is to record what's actually occurring in court, and we don't do commentary. So by seeing with their own eyes what's happening, they form their own opinion. It's very different than being told. Telling somebody what's going on in a case is very different from showing them. has a very strong impression on the viewers
Which is true.
to see for themselves the manner in which the court conducts itself and the participants.
And you've had no issues in this case with any of your covers? That's
None whatsoever so far.
okay. Well, thank you, Judge. No further questions.
Let's actually start with Mr. Hillygus on this, and then I'll come.
Oh God, here we go. All right, Hillygus is about to speak again. Everybody get ready. Psych yourself up and prepare for the crazy.
Back to Mr. Silverberg. Mr. Hillygus, do you have any questions of Mr. Falcone?
I don't really have any questions. I just want to thank him for his coverage, and I believe it's important what he's doing to get the community involved in seeing how the court operates, and I'm all for cameras in the courtroom.
Thank you. Mr. Silverberg, any questions?
Well, I'll be damned. Well, that happened. What the hell? I did not see that coming. Well then.
Questions?
No question.
I assume that on behalf of your client, you echo what Mr. Hillygus said.
Precisely.
Okay. Any additional questions? Anything else that you'd like to say that if somebody had asked you the right question, you would have told us?
I think that all of the right questions were asked.
Okay. Anything else?
I asked questions, I didn't state my position.
Okay, well, I'll let you summarize where you are in just a minute. Thank you. You may step down. I appreciate you being here and responding to the court's concerns.
Listen, thank you and acknowledging the benefits of transparency of cameras in the courtroom. All right.
Way back to the scene. I just want to observe this.
Pog.
You know, we're all aware that during jury selection, one of the questions the court always asks, and if for some reason the court overlooks it, counsel will ask is, have you heard anything about this case? Do you know anything about it? Have you seen it with directly or somebody mentioned it to you? Do you believe you know anything about it? Have you read any newspaper articles, gone online?
All right, y'all in the chat need to stop like violating the like button. All right, it's getting kind of sus.
Know any of the accused, know the prosecutor, know the court. So there is that, and they're under oath when they answer those questions. So to the extent that somebody would have taken notice of anything our Nevada judges or any other news media has posted, we would expect them to truthfully explain what they have, and then we'll discuss with them whether that would impact their ability to be fair and impartial. I wanted also, before each side summarizes their views, you know, Mr. Hillygus and Mr. Stadium and Mr. Silverberg on behalf of Mr. Hanty have already indicated they have no objection to this and they're in favor of it. So that's noted. But I want to tell you that I'm still not going to make a decision on this till after the hearing, the Monday before the trial, after I determine whether this is going to be an anonymous jury. Now, having heard from Mr. Falcone that they don't record the jury selection process, that gives the court a considerable amount of comfort that shouldn't be a factor. But I'm still gonna just chew on this a little bit more, but I wanna make sure people know the court's decision at least a week before so they can govern their actions. But what do you think that this is showing the court and what the court should do? Then I'll ask Mr. Stakey.
Thank you, Your Honor. Under SCR 230, of course, there's a presumption that electronic media coverage should be permitted. And we believe our Nevada judges, based on the testimony of Mr. Falcone, squarely meets the factors in favor of providing coverage with reasonable limitations as conceded by Mr. Falcone. And, I think his testimony did a fantastic job of allaying any concerns about the impact this coverage might have on the public, in that the antidotes to misinformation or threats or allegations against public officials or court, etc. I mean, the best antidote to that is the truth, and if the public can see for themselves what's happening in the court, it goes a long way in dispelling.
Question. So if I do get a subpoena for this, but I have watched your vids on it, as long as I can be impartial, I can sit on jury. I don't know. If it was up to me, I'd probably bump you off. If I'm being perfectly honest.
Those problems on its own, Your Honor.
Well, I also heard him say that if the court grants a request but orders that that this not be published till the jury verdict has been reached, or if they're unable to reach one, I've excused them because they're at an impasse, because of concerns about witnesses potentially going online to see what other witnesses have said in violation of the exclusionary rule if invoked. And let's remember, the state can invoke it, either defendant can invoke it, or the court on its own initiative can invoke it. So it's likely to be invoked. I have not had a jury trial that I recall where it was not, so let's all assume it will be. And you know, I understood Mr. Falcone to rather politely say that's not their preferred approach, but if that's ordered, they'll follow it because they don't want to interfere with the proceedings. So if that's ordered, I'll expect it to be abided by.
And thank you, Aaron. Just to summarize Mr. Falcone's general position is one of being eminently reasonable to consider what the court thinks is important insofar as limiting what the jury, if the jury's filmed at all, that's my number one concern, that that doesn't happen. And that Mr. Falcone will react reasonably to orders of the court within the scope of SCR 230 to accommodate any issues that do arise during the proceedings.
Okay.
And with that, Your Honor, we believe, because all the factors weigh in favor of media access, that you grant the request under Rule 230.
Okay, now you heard, thank you. You heard what I said. I'm really not prepared to make a decision on this until a week from Monday, which is a week before the trial. I know you wanted one today, but I may not come until 10 days from today. You understand that?
Understood.
All right, Mr. Ziggy, what's your position based on what we've heard?
I anticipate that the court's going to grant electronic access.
Well, you want me to tell you where I'm leaning? I'm leaning toward granting it.
Right. So they've been with, they've shown in this case, you know, they are abiding by the rule. I expect the court to think about some of the things, you know, that impact on the jury veneer is an issue in this case. It's been an issue in the case, particularly Mr. Henke and Mr. Hillygus seeking status as media darling.
Well, let me mention
as well as the harassment piece.
Right.
So,
Okay, so if I wasn't able to hear before, but what it sounds like to me, what the prosecutor is saying is that it's already so far, probably Hillygus's crew have already started sending certain messages, obviously because of this whole the Republic of Texas thing. So the prosecutor is saying that we're already starting to get certain kinds of messages and comments by people more than likely from Hillygus's camp. And he's expressing the potential concern that these same people may go after members of the jury. And I think that's what he's expressing here.
So I expect the court will craft an order balancing those factors in allowing electronic coverage.
Well, thank you, and I'm leaning toward granting.
Mad about what?
Two or three things in particular stood out to the court. One was that Mr. Falcone is planning to be here himself for the vast majority of the trial. So if an issue arises, we can get his attention rather quickly. Two is not seeking to live stream. And then third, not the jury selection process.
Scooby?
So those, those are three important factors. The other thing is that I'll have to give some more thought to the rule of exclusion. Well, let's go right to it. Does the state anticipate requesting the rule of exclusion on witnesses?
I've been a trial attorney for 20 years. I've never seen a trial bench or jury that wasn't.
Unforgiven witness. The problem that you're having is, and this now I understand why the judge potentially said that we could make the jury anonymous. There's going to be an open question whether to make the jury anonymous or not. It's because Hillygus is pro se. And if Hillygus knows who the members of the juries are, he could probably leak to his comrades who the jurors are, and that's how they'd get them.
Involved, and will be in this case.
All right. So the state's invoking.
Well, yes. Yes.
All right. So with that understanding, I'll give some more thought to this, and I will pronounce on the record Monday, the 21st, what the court's decision is, but again, unless something changes in the court's thinking, the answer to that is going to be yes, coverage is approved. The court allows, well, let's back up. Ms. Falcone, you can avoid sending a written request in. Do you seek to be here for the hearings on the 21st and the 23rd?
Yeah, not personally, I'll send
But have somebody here.
Yeah, I'll send a camera.
Mr. Steggy, any reason the court should not allow that?
I haven't objected to any of them so far.
Granted. With respect to Mr. Conrad's on behalf of, if he seeks to do that, which it sounds like he's going to, please put that in writing, Mr. Conrad. I'm going to let the state look at it a little bit more, and then you'll have a decision on that just as promptly as we can. Mr. Conrad, do you have a question?
Your Honor, is the form going to be updated on the website so there's a little more clarity in this process? Because when I sent that email a few weeks ago, I thought I was abiding by everything required. Apparently I didn't.
Or you did and it just got overlooked.
Okay.
So what I would say is do what you're doing. In terms of the form being updated, I know it's in the works to have consistency among the different departments. I'm not aware procedurally or logistically where we are. But if you email Alicia LaRude, I'll make sure that we respond properly.
I just did.
Right. And again, I apologize for the disrupt that happened here. All right, let's move on. So, anything else before I excuse you, Mr. Busby?
Nothing at this point, Your Honor.
All right, you're free to stay and observe, and if not, you're free to go as well. Same with
If I'm free to go, I'm free to stay.
anyone else that had an issue on this regard. Thank you. Wish you a pleasant afternoon. Right, exclusionary rule is invoked in the trial in this matter. Motion to confirm. Is the state prepared to go forward on the 28th?
I anticipate being ready to go forward, yes.
Or Mr. Hillygus, are you ready to go forward on the 28th?
I do not consent to this.
There. All right. There we go. All right. Now we're back to normal Hillygus.
And I don't believe that this court, as you know, they don't have the ability to move forward because of the all this stuff that is on the record. And so I do not consent to your to contract with your corporation.
Understand your
Okay.
position. Mr. Silverberg.
Your Honor, I don't believe that I will be ready. If Your Honor wants a written motion, I'll prepare that in light of both my own trial calendar and issues related to the Young hearing have hindered my ability to be prepared. Mr. Ante, I can tell Your Honor feels the same way.
Okay, well, right now I'm not slowing the train down. However, if you file a motion, please file it by Monday, close of business, make sure it's not just electronically filed because it can take a few hours for it to be processed and then appear on eFlex. If you would provide whatever's filed, of course, courtesy copy to the court to Mr. Steggy, and however, Mr. Hillygus is getting his messages as well. So we all have it as quickly as it's filed. And then to the state, you know, I'll give you 48 hours to respond to any motion to continue. And then I will take it up on the Monday morning, the week before the trial.
Thank you.
All right. Let's move on. Mr. Hillygus, you heard my preliminary comment. And by the way, I know that for my staff here, we've been here for close to 2 hours. If anyone here needs a short comfort break, please just get my attention and we'll stretch our legs. All right, let's move on. Mr. Hillygus, you heard when I sat down, I talked about having you dressed properly for court. I don't know if you've given that thought and you have a position on that you'd like to share, or you want to give it some more thought. I want you to be dressed appropriately for court. I can't force you to dress a certain way, but what I can do is, if you want to be professionally dressed or appropriately dressed for court, Mr. Ante, he can look like this, that's appropriate. He can put a suit and tie on if he chooses to do so. The study after study suggests, however, that if a jury learns that somebody's in custody who's accused of a crime. It generally works for their disadvantage. So if you're in jail clothes,
Yeah, Daryl Brooks didn't understand that.
then that's usually not a good thing. So I want to give you every opportunity to wear more appropriate clothes. Have you given any thought to that? And if so, can you tell me what you think it is?
The state should provide a tailor, and I should be tailored, measured for proper clothing, suit and tie, and shoes and socks and belt and the whole 9 yards.
So
So
when-
what you're gonna do is you're gonna force me to appear at a trial. I need to be properly dressed.
Well, do you have clothes on your own? You're self-represented. You don't have an attorney on this case.
What you see is what I got.
And there's no, for example, there's no clothes in Texas or wherever you have your stuff that you can get here and that you want to wear.
The state needs to provide a tailor. They need to
Oh my, what? What? He wants the state to give him a tailored suit? No shot. No shot. That's what he's gonna fight about? He wants a tailored suit paid for by the state? The chutzpah of this guy. And he's trying to pull a direct D, saying, oh, I only have the shirt on my back. Bull. BS. Oh, this guy. Oh my God.
come in and measure me and give me proper suits and shirts and more than one. A shirt.
More than one even. He wants multiple shirts. You know, because the other one got to get laundered, apparently. Dry cleaned even. Paid for by the state.
Every day, and I need to be properly clothed. I agree with you. I don't want the jury to reflect on me as being somebody that's in custody. I'm a professional. I've 30 years professional for this state.
I got
I've
it.
never been
So let me-
accused of a crime, and I haven't committed a crime.
Okay, so what I have to do is think about the best way to get this done. Because
Finally, I unlocked the best gun in the game.
I've never had a case where a self-represented defendant was somebody that the state was ordered or the county was ordered to provide clothes that was not represented. It's a little awkward. I have to figure out what the procedure is. I
Yeah, kinda.
may fashion an order directing the Washoe County Sheriff to use best efforts to get you professionally dressed and ready for court. Whether that involves having a tailor come to you to measure you up, that's not likely. To get you clothes that fit reasonably well and make you appropriately attired for court, that's likely what's going to happen. Mr. Steggy, do you have any thoughts on how that might work?
I would be surprised to see an order directing the sheriff to do that. I think by practice, custom, and law, you know, the defendant has many allies, right? So that's usually provided by the defendant himself, his family, or his allies. If those three things strike out, then I would expect an appropriate motion before the.
Well, we're 17 days out.
Right. I think this man is expecting a tailor. There will be no tailor.
I would object to Mr.
Hold on,
Steggy.
hold on. I'll let you go.
So I would suggest, rather than coming back to 21st, that this issue be, well, that between now and then, the defendant be directed to make efforts to and come back with a plan. Not just a passive aggressive, I need a tailor, but an actual plan. I reached out to my family and my allies, and I have or have not had clothes because it was not supported by the law.
Yeah, go find a local Goodwill. Go to a Salvation Army. Seriously, the audacity of him not asking for a tailored suit, shirt, and shoes. Oh my God. Yeah.
What about the court appointing the Washoe County Public Defender as standby counsel for the limited role of assisting with properly clothing Mr. Hillygus for the court proceedings?
Well, I would not.
Speaking of shoes, I actually do need to get new work shoes.
To sort of speak for them, but based on what we've seen in prior hearings, I foresee resistance by them to such efforts. Now, if the sheriff is willing to do it, I imagine someplace they have clothes for people, for example, who come in with insufficient clothing, that they can, a closet for that, but I don't think we should make this a big issue.
What if Mr. Hillygus was indigent and he's self-represented and he couldn't afford nice clothes for court? I mean, somebody has to do something. So I'll figure out an approach here. Let me tell you the way I'm leaning. The way I'm leaning is we go two directions. One, that the court directs you, Mr. Hillygus, to use your best efforts to reach out to people that support you to help you with this. And two, the court reaches out to the Washoe County Sheriff and finds out what they're capable of doing. And then maybe I issue an order directing them to use best efforts. Best efforts is a legal term. That means to try really hard to get you fitted properly for court. Does that mean we're set for a 9-day trial. You understand one of our days for our 2-week trial is Labor Day. So we're set for a 9-day trial. Does that mean 9 new suits? No. Does it mean dressed appropriately for court? Yes.
I would object to any used clothes. I want new clothes. If you're gonna provide me clothes, I need to have due process. The state is trying to diminish my ability to look proper and wants me to be slavish and wear some used.
Oh my God, I'm doing everything I can to avoid swearing right now. I'm doing everything I possibly can to avoid swearing. Oh my God.
Don't fit properly. That's not who I am.
This man owns property. He can afford to be on the run for 9 months and was protected by a whole group of sovereign citizens. Today,
yes!
we're trying to,
Get his fellow American nationals to donate some money for him, or donate some shoes for him, and donate some suits. Get his American national buddy to do it for him. Oh my God.
and by not writing a paper is inconsistent with reality. I do want to, the court mentioned with respect to Mr. Silverberg's motion, the state has 48 hours to respond, but we're not going to hear this until the Monday before trial. I like to humbly request, if we're doing it in that short of an order, we need a decision from this court in a hearing. The reason being, there's a lot of pieces in motion for this trial to occur, and to call it off a week before is cause expense.
Call on me. I have a 15-count sexual assault trial starting tomorrow at 10 a.m. And in addition to that, I have other matters on my calendar, even during the trial week. I will be able to give that issue very little time and effort, and that includes the court working nights and some weekends. What I would suggest is this: Mr. Silverberg needs to file this motion as soon as he can. The state should get its response on at least 2 days before the Monday hearing, before the Monday trial. That is the soonest I will be able to rule on this, because I want to give each side an ability to argue their position, not just put it in writing. So if Mr. Silverberg were to file it Monday, then you can have until Thursday, I guess, at the phone.
I'm fine responding. I can respond probably in 24 hours.
So you
I
just
don't
need to-
like that I have to respond, and we're gonna wait a Monday hence, while both parties must prepare for trial. And if the court continues it, that comes at expense to the state. I am very sensitive to the demands of all the parties, and I'm just simply asking, if possible, to avoid waste in that regard.
So here, let me just tell you this, I hear you. It's not optimal for a motion of this importance to be ruled on by the court. A week before, we're supposed to pick a jury. That is not generally how this goes. The fact, though, that this hearing ended up today, and this issue became apparently organically, is a product of the court couldn't get this hearing really sooner. And so I'm doing the best we can. That's all I can say. And I know we're all gonna know the Monday before the trial. Okay, let's move past this. Mr. Hillygus, here's the court's directive to
I
you.
don't have any family. I've lost all my family. I don't have any family here to try to provide me any clothes. I don't have any money on my books to buy any clothes. I don't have the ability to talk to people that live in other states to provide me clothes. I'd like to be dressed properly, if that's what you're gonna do to me. Because you're gonna provide
Hillygus, I'm the one
used clothes
Hold on.
that don't fit.
Mr. Hillygus, the court's the one that's bringing this up now. The court's the one, maybe you were assuming all along that this was gonna happen, but when somebody does not have an attorney and they're in custody, this is an unusual circumstance. So the court has to anticipate in advance how this is gonna go. That's why it was on my list of important things to go over with you. Let me work on fashioning a remedy here.
Baki, thank you for the 150 secs for yours and Archer's recovery. I appreciate it, man. Thank you.
Make sure that you can truthfully say, Judge, I reached out to the people that are in my camp, that are supporting me, that are helpful to me, that are friends with me, to see if they could help out some way.
Nobody's financially supporting me, I can tell you that. So I can reach out to people that know me, but they're not financially supporting me anyway.
Fair enough. I have to think about this. We're gonna make sure you're dressed appropriately for court. All right, let me move on here.
Is that it? Or is there more? I have not tried the zinger yet. Ow.
Yeah. Okay. We're almost done with this hearing anyway, because the things I wanted to go over, my staff needs a break anyway. The things that the court wanted to go over, we've gone over. The next time I see you will be a week from this Monday. We're gonna finalize the court's decision on electronic coverage of the trial. We're going to discuss the jury, anonymous or not. We're going to hopefully have an update for Mr. Hillygus about how and who's going to attire him for court. I want parties to give more thought to the court's thinking that Mr. Hanty's ankle monitor will come off daily during trial weeks. I've already told you, Mr. Hillygus, if you're unwell or in need of a wheelchair for entrance into or leaving court, or while in the courthouse, I need.
Who keeps bonking the mic?
Evidence that is necessity or indicated for you before I can allow that. I'm not looking to make it difficult for you to have it available if you need it, but I need to see a reason that you do need it. So get something on file or be prepared when I see you on the next Monday to bring that to the court's attention.
The sheriff's department has determined that I'm ADA, so I'm Americans with Disabilities Act. They're the ones that have provided me the wheelchair that is medically in my records there. I don't know what else to tell you, but I'm being denied an ADA advocate that I need for this case. I have an ADA advocate that works at the sheriff's department that comes and sees me and makes sure that I'm getting what I need, which they're denying me hygiene. I'm not getting showers regularly.
Well, hold on, I don't want to hear the list of things that the sheriff is not doing that it's supposed to. What I'm saying is, if I'm gonna allow a wheelchair, I need some good cause to allow. That's it. And
They're
so
providing me a wheelchair.
we're gonna button that up when I see you on Monday the 21st, okay? Do you have a position on that quickly, because
No.
we're gonna take a break?
No, I just want to correct the record. It was stated that there's a judgment and justices. That's, the record should accurately reflect that's a fake legal document.
Yeah, I was gonna say. Yeah. By the way, the so-called justices document that's supposedly default judgment against you, judge. You know, that's from the Republic of Texas, LARPer.
There's no such judgment.
LARPer Federation.
More sovereign.
I want to make sure it's clear that what I was saying is I reviewed briefly the document that purports to be a judgment signed by 3 justices from the Republic of Texas. Okay. All right. With that, I will see everybody on the 21st at 9:30. Thank you. With that, the court will be in recess.
Thank you, Your Honor.
Thank you.
All rise.
So that was it. Wanted me to go insane about Hillygus actually asking for a tailored suit for his trial at state's expense. Unreal. Hang on. Oh god. All right. This one is in my feed. It looks wild. I'm kind of concerned.
Let's go. Please.
I will never let go! Leave me alone!
Okay.
Leave me alone!
Relax so you don't get
No!
hurt.
I don't care! I do not care!
Welcome back, viewers. I'm Cam Anthem, and this is Civilian Crime Cam.
Viewer discretion is advised.
Today we're in Harvard, Illinois,
Wow.
the self-proclaimed milk capital of the United States, and home to Harmilda, the fiberglass cow, and the longest-running outdoor festival in the state.
Actually, okay. All right. I thought this was just the footage itself. But Donut actually had something that was actually really interesting. That he posted not too long ago. Yeah, this one.
Drop the pipe! Drop the pipe! Mav, drop the pipe!
Hi everyone, Donut here. I haven't done a shooting in like 2 weeks since the one cops almost killed their friends in that really crazy crossfire. Say that 3 times fast. Somehow no one was hit during that. Divine intervention. Go watch it right now. I got you a shooting today though where a lady is running around Tent City doo-doo land just booping people on the head with a metal pipe. She's just giving people little boops. Before we get...
Yeah, so, yeah, so people in the comments are saying that that's not just some regular metal pipe. It was a freaking barbell, like, bar. Like a solid barbell bar. So that thing could have done some real damage. And, well, to the point of killing people.
Into the metal pipe booping spree, we should probably talk about the best way to hear those boops on old lady skulls. The best way to hear that is from my sponsor, Raycon earbuds. You want to listen to people get hit by cars while running from the police in crystal clear quality?
He just got hit!
And you want a pair of earbuds that start at half the price of other premium audio brands? That's where Raycon comes in. Raycon! Raycon's been one of my longest running and most trusted sponsors. I've kept this sponsor around because I really like their product. With 8 hours of playtime and 32 hours of charge time on the battery case, you can't go wrong. They don't fall out of your ear either. I'm going to be using my Raycons when I get on an airplane here in a couple days to go to Nashville and watch Brandon Herrera beat the f*** out of Action Man. Why will I be using my Raycons on an airplane? Because babies scream and they have noise isolation that you can easily get to with the click of a little button. Look, everyone's ears is different, but they got different fits and colors and styles for everyone. Look at these Raycons. Look at these Raycons. Look how happy this motherfucker is with his Raycons. So if you want to help support my channel and get a badass pair of earbuds, then head on over to buyraycon.com/operator and get 15% off right now. Raycon. Now let's get on with the shootings, but first I just want to say LAPD does an excellent job with their breakdowns. Hosted by the wonderful yet a little bit monotone Kelly Munoz. I'm pronouncing your name wrong. Not on purpose, I'm dumb. I just wanted to talk about their breakdown a little bit because they get silly. And I know it's for legal reasons, but it's silly.
Yeah.
I enjoy the little things in life. Like one of the largest police agencies in our entire country having to be PC when they're showing a video about a lady getting shot.
In addition, There may be strong language used by those shown in the video.
She's like,
oh no,
sorry, there may be some curses in here during this video of a lady being legally murdered. And I mean, I understand it a little bit, with everyone being sensitive little b****s, especially in California. LAPD doesn't want to get sued by someone's extended family who hasn't talked to them in years just because an officer said during an arrest. He was a good boy. Let's get on with the metal pipe boobs and a shooting. July 9th, 2023, 9 a.m., West Los Angeles. People started calling in to 911 and saying, hey, there's a crazy walking around doing boops on random people with a metal pipe for no damn reason. But that's a good reason for police to be dispatched.
I'm on Reseda and Hatteras, and there's this woman in gray sweatsuit type thing, a onesie, holding a jacket with a metal pipe, and I just saw her assault this woman that's walking her dog.
And that's not the only call that LAPD received. A Hispanic man calls in and says, hey, a lady got booped on the head by some other person. She's laying on the ground bleeding.
Mande, hay una señora golpeada, ¿dónde?
Golpeada de la cara, se cayó y está sangrando mucho. Sí.
So at this point, dispatch is still confused whether or not a lady got hit by a car or there was some booping. But then the housekeeper from Family Guy called in and cleared everything up.
I'm with a resident bleeding, and according to her, she was taking a walk, and I did somebody hit her, and she fell.
Okay, so a car hit her, ran her over.
No.
No, there was no carro.
We're in the street right now. No, there's no car involved.
I think she got assaulted, correct?
Huh?
So it wasn't the car that hit her then?
No car involved, sir.
The plot thickens. Then another guy calls.
Bleeding and something else. I'm about 50 feet from it right now. I'm watching other people.
All right, are you able to get near her to see if she's alert and answering questions appropriately?
There's about 3 or 4 people around her right now. She seems to be conscious and talking.
LAPD actually put out about 10 minutes of phone calls where people were calling 911 saying, hey, someone running around with a pipe booping people. This is not good. They need to get their 40 Mike Ouchie rounds, tasers, and guns, then head out there immediately, foreshadowing. How do I know they need to stop her quickly? Because I know that a metal pipe can be a deadly weapon. I actually tested this theory last year when Ballistic Dummy Labs was nice enough to send me a couple of their corpses. Check this out.
What's right is right. They don't give a f about
So big, leave him alone.
Oh my God.
Frankie.
Now that we know a metal pipe will absolutely f your shit up, let's watch some of the security camera footage of this lady going around doing the boops. You're gonna be f***ing tired of the word boop after this video, I swear.
Ah.
He was even called on cell phone footage by someone standing aside watching the boops.
Oh!
So LAPD rolls out and finds 4 victims total. They run in one guy that saw the boops.
My neighbor got hit in the head with a pipe by some man. My wife took her to the hospital. I think she's there right now, but I did a quick sweep. I didn't see anyone with driving around. I didn't see anyone with a pipe. Just want to point that out in case, you know.
Did she? So your wife took this other person to the hospital?
Yeah.
Then they find an elderly victim in the back of an ambu.
It's just like out of nowhere.
Totally unprovoked and just,
Okay.
5 minutes after they located the elderly victim in the back of that ambu, they found our suspect at a gas station with the booper still in her hand.
Hey! Drop the pipe! Drop the pipe! Ma'am, drop the pipe! Drop the pipe!
That's right, she took a 40 Mike Ouchie round, one of those foam bastards, to her chest like it was nothing and kept advancing on the officer.
Ma'am, drop the pipe! Drop the pipe! Ma'am, drop the pipe!
Wait a minute, where's this secret booper hideout that LAPD was blurring in their press release of the shooting? Enhance. Enhance. It couldn't be the 76 gas station at the Burbank and Rosita. How did I ever figure that out? With my super high-tech crime software, of course. I'm just kidding. The f***ing cop said it like 3 seconds later.
We're gonna be on Burbank and Rosita.
Oh my god.
LAPD is f***ing silly sometimes with their media releases. Anyways, the lady got shot 3 times while taking a 10-second taser ride. Let's watch the officer's body camera footage with the 40 mic.
For me, well, when I first saw it, it didn't look very clear to me from the, well, I think it's because of the blurring. It didn't look clear to me, but when you got the camera footage from the other officers, you see that she was right on top of the officer with the firearm. Yeah, see that right there.
Dude, she really brushed that 40 mic off. I want to smoke some of what she's smoking. We got another angle too. Let's watch real quick. The officer with the taser. This one's important because you can see how close she came to booping the officer who had the lethal cover. Lethal cover, of course, you need when you have officers with non-lethal cover in case things go wrong, which it almost did. They just happened to tase and shoot at the same time. It happens. Officers immediately started CPR, but unfortunately she had way too many holes in her chest and she passed away in the hospital. If you want to see the raw footage of this without all the blurs and the weird noises,
I'm good, thank you.
To keep a roof over my head, then you can go watch that over at Donut's raw police footage. In the meantime, if you want to help support the channel, go on over to donutoperator.com, get some super sweet merch, and just follow me everywhere. Until next time, please have a fantastic day.
Whacker.
Oh boy.
Hello. Hi, how are you? So listen, the reason I'm stopping is my license plate reader in my car. When you drove by me, it's showing this vehicle's uninsured. You do?
Ooh, uh-oh.
All right, you got your license and everything on you? Do you know if maybe you haven't sent it into the state of Florida? Like, is there a reason why it wouldn't be on file with the car?
I don't know. I know they sent me something saying I have to send it to them, but I never got a chance to do it.
Okay.
I have an appointment.
Okay.
So I'm waiting on my appointment to send it to them.
I got you.
Okay. Because, you can't do nothing. You can't do it online. So.
Yeah, no, I feel you. Yeah, so if you got your registration and if you have a copy of your current insurance. And the car's registered to you?
Yeah.
Okay. All right, cool. How's it going?
I got pictures in here, so hold on. Yeah.
How's it going, man? Good. You got your ID on you? Because you're not wearing a seatbelt and the car smells like weed, so I need your ID. I need your ID. Well, car smells like weed, man.
I don't smoke, so how I smell like weed?
I didn't say you were smoking. I said the car smells like weed. Because the car smells like weed and you're not wearing a seatbelt. Okay, that may be, but the car also smells like weed and you have weed shake on your lap. Okay?
What's the I keep forgetting. What's the law on recreational marijuana in Florida? Is it still legal over there? I don't remember. Okay. So if he smells it and then he says he has what did he say that he had in his lap? I forget what there was. That I'd say that, yeah, that'd be enough independent probable cause to ask for his ask for the passenger's ID.
I mean, it's weed, man. It's not a big deal. I mean, I could care less about weed, but it's. How am I acting weird? I've been nothing but respectful. I'm not mad at you, sir.
Oh, in the seatbelt.
By law, you have to give me your ID. When you do. When a car smells like, you by law, you have, sir, when the car smells like, I'm explaining the law to you. I'm sorry? Okay, well, I'm explaining it to you because you seem to not have an understanding of how the law works. All right, when the car...
Can you put on the mask, please?
When the car smells like...
Why you can't put on the mask?
I'm vaccinated.
It don't matter, you in my face and you got spit coming out.
Call him out. They're being... It smells like weed and they're giving me a hard time.
I'm not giving you a hard time.
Unlock
I'm looking for the stuff. Yeah.
Car smells like weed and they're giving me a hard time.
I'm not giving you a hard time.
All right, let's put your hands here, man.
Why are you doing all this to me again, bro?
This car smells like weed. You're just gonna go in handcuffs till I figure out what's going on.
I'm gonna go in handcuffs?
Yep, car smells like weed and you're being a little difficult with me, okay? You get one more minute.
I really see it right now, bro.
Give me your other hand.
Why are you putting me in handcuffs, bro?
Well, you didn't want to identify yourself to begin with.
I gave you my ID on camera, bro.
You did. The car smells like...
Is your thing running, bro?
Yes, sir. Car smells like weed, so
you really finna put me in handcuffs for no reason, bro?
You're in handcuffs because the car smells like weed.
That's not no proper cause to put somebody in handcuffs, boss.
I don't need proper cause.
Yes, you do. You put me in handcuffs and violate my rights, man.
I need reasonable suspicion.
No, you're violating my rights, bro.
No, you can be detained, which means they can put you in handcuffs. It's usually a matter of different factors, including time, that can, upgrade a detainment to an arrest. And if the cops still only have RAS and not probable cause, while they're having him, while it would be considered to be an arrest, it would be a false arrest. But they can put you in handcuffs for the purposes of detainment, right now.
Oh, that's real shit, bro. I can't believe you really doing me like this. Because I'm black, bro?
That has nothing to do with it.
Are you violating the fuck out of my rights right now? Okay. Let me get a sergeant here, bro.
You can go to the police department after the traffic stop and file a complaint.
I need both of you guys' information, please.
I'm Officer McGillicuddy.
I need a card, boss.
Sure, my bad.
Is it? Wait, this officer's actual name is McGillicuddy? Oh my god. That's the most stereotypical cop name ever.
Listen, my badge number is 1216. You're giving me a hard time. The car smells like...
I'm not giving you a hard time. I asked you simply why.
Come sit over there.
That's a hard time. I don't want to sit on the floor, boss.
Sit on my bumper. Just hang out with him. All right, listen. The car smells like...
Okay.
All right, do you have a medical marijuana card?
I don't smoke.
Okay, go and step out of the car for me.
Well, hold on. Can you wait? I'm trying to get my window.
No, I'm telling you to step out of the car. Ma'am, step out of the car.
I'm trying to get the
I'm
stuff.
telling you to put the phone down and step out of the car.
I'm not putting the phone on because I'm getting the stuff that you told me.
I'm telling you to step out of the car.
Okay, I'll step out of the car. Don't put your hand on me. Don't put your hand. Don't put your hand on me. Don't put your hand on me. I'm getting. Don't put your hand on me. It's your friend. Don't put your hand on me.
You're under arrest.
No, I'm under arrest.
You're under arrest.
I'm under arrest. Don't put your hands
You're
on
under
me.
arrest. Turn around. You're under arrest.
Don't put your hands on me.
Going fighting. Turn around.
What the fuck?
Turn around.
Don't put your hand on me.
You're under arrest.
Don't put your
Turn
hand
around.
on me. I'm trying to get.
Turn around.
I'm trying to get lucky ass first.
Turn around. Turn around. You're gonna get tased. Turn around.
What the fuck? He told me to look for that shit.
Sit him down.
And now he's.
Well, now you are under arrest.
How am I under arrest? How am I under arrest?
You doing fucking Instacart, dog.
Push me when I try to put your
I did not push you. You put your hands on me. You put your hands on me. Sorry, this might hurt a little bit. I'm pregnant. You got to put it in the front.
Got the driver, the Battlebit, and alright.
I'm pregnant. You have to put it in the front. How many months are you? I just found out I'm pregnant. I got it. Why you put your hands on me like that? Weird. You tell me.
13 supervisor, there was no use of force, just she pushed me and we had to...
You put your hands on me, and I got a bust lip now. You put
She's got a what? She's got a crushed what?
your hands on me. You got me down because I don't need you.
Stop it.
What is you doing?
You're under arrest.
Okay, but I need to get my insurance and stuff.
We're way past that.
No, I'm finna call my mama. Let me go to the cell phone. I'm finna call my mama. All right.
Get in my car.
I'm calling my mama.
So I would say, I mean, they could have de-escalated a bit better. but I'm playing armchair. Ultimately, I don't think they did anything. I don't think they did anything inherently wrong. I just think that they could have de-escalated a bit better. But you know, she was kind of acting. She was acting wild.
I don't have nothing. All right.
Are you really doing this shit?
I don't have nothing. Why? Weird as fuck.
Oh, don't worry, he's on the way.
Can you loose these out? This hurt my arm. And I'm fucking pregnant. The fuck? This one hurt my arm right here. This one hurt my arm. Keep it like this. Okay, no, can you loosen this one up right here? This one hurt so bad. It's 3 fingers I got. I know, but this one hurt.
Ma'am, when I'm putting you in handcuffs, you're not allowed to push me.
I didn't push you. You put your hands on me. My fucking lip bust now.
Go, get in the car.
He was putting hands on you because he's going to put you in handcuffs.
You're under arrest.
Have a seat.
And did I fight you? Did I do anything wrong?
Proud there, you know, stop working. She resisted when I tried to handcuff her and she pushed off me, but we got her under control using regular leverage techniques or no strikes or anything.
Are we putting him in the car? What are we doing?
What's that?
Are we putting him in the car?
He's not under arrest.
Oh, he's not?
He was in handcuffs because it smelled like shit. I tried to pull her out and she got combative. Shut up, I'm not talking to you. I'm not talking to you. I can and I did. Sir, you're in the car, okay?
Hey, folks, I really want to know why I'm in handcuffs, bro. I really want to know why I'm in handcuffs.
Because the car smells like.
Bro, what the fuck does it have to do with me being in handcuffs, bro?
I don't look a weed bag.
A weed bag?
All right, are you gonna let me talk to you now and explain to you why you're in handcuffs?
Bro, you just picked up a bag and said a weed bag on camera, bro.
Be quiet. I pull you over. The car smells like. You're non-cooperative. Don't want to give me your ID.
I gave you my ID.
Hold on.
I ain't give you my ID.
You did. After I informed you that you had to.
And I asked you why once.
The car smells like. So I put you in handcuffs.
For what?
Because it smells like I'm conducting a vehicle search. I don't want you running on me.
Bro, I wasn't even driving the vehicle. Okay. How can a passenger be put in handcuffs because it smells like bro?
You can ask your lawyer.
You know how many times I got stopped before, bro?
I then order her out of the car multiple times. She refuses. I then go to take her out, and I put my hands on her, and she pushes me. That's
bro,
battery. That's battery.
And mentally abusive, right?
Sir, everything's being recorded. I've done my job professionally.
Bro, you didn't do your job professionally.
Mentally abusive.
Okay. You can come file a complaint. I don't really care.
Bro, I have to. Like, you doing this shit unlawfully.
You obviously don't know what the law is.
No, you.
I mean, he did at least very sure. Here, he at least the officer, or at least he tried to explain to him exactly why he's in the situation that he's in. So I do give him props for that. Obviously, the guy's not listening, but he did try to his best to explain to him what the situation was.
Don't know how to fucking
I'm gonna call rescue just to make sure she's okay.
Yeah, that's fine. Whatever. Did the sergeant explain to you why you got put in handcuffs?
No.
All right, so you've been arrested for selling before, right?
I have been arrested.
So you know what marijuana smells like.
How have I been arrested?
Hold on, I want to explain it to you in front of the sergeant so we're all on the same page.
You just heard what you just said to me, though, bro?
You didn't want. Hold on, listen to me. You didn't want to provide me your ID, and by law you have to.
Why are you lying?
Okay?
I gave you my ID instantly.
Hold on, you're not letting me finish.
You lying. You can't lie and keep going.
Sir, I then informed you that you have to provide it, and you did.
Okay. So what happened?
We were then to conduct a vehicle search. I had you step out of the car, and
then you instantly put me in handcuffs.
I did.
Why?
Which I'm allowed to do because I have.
No, you're not.
I have probable cause to believe.
You don't have probable cause to put me in handcuffs.
Turn around. You're gonna get taken out of handcuffs.
I don't get why I was placed in handcuffs, bro. I didn't threaten you.
Because you were amped up.
How was amped up?
You're amped up right now. Hold on.
So if you show me on your camera to all these folks, I was amped up talking to you.
It was on the whole
time.
Bro,
I asked you a fucking
when I conduct,
why do you need my license in handcuffs?
Hey, sir, you gonna let me talk? Senator, you let me talk? When I conduct a vehicle search, I'm allowed to put you in handcuffs for my safety, okay?
That's fucked up, bro.
And then when I go to take your girl out of the car and put her in handcuffs, she wants to fight
me. You already put me in handcuffs and made her scared, bro. And you really think somebody's gonna corroborate?
All right, go ahead and hang on the front of my car for me. Sir, go ahead and hang on the front of my car for me, okay?
I really gotta go with this.
Sir, here's your ID back. You're welcome. No, we're not calling anybody.
I don't care. He can call them. I don't give a f if you don't call. They gotta give a f bitch. Ball head, bitch.
Back up a foot. His legs went under your body.
Ball head ass bitch.
That's very nice of you.
Bitch, I don't give a skit ball, bitch. Oh, you mad because you probably ain't got no motherfucking wife or no girlfriend. Long ass.
Oh my god, where are the bingo cards? Oh. Right there. Oh, is that the end of the video? Yeah, they ended right there.
One of our officers, you're coming through.
Jesus. All right, I think this is where we're gonna. I think this is a good time to take a pause. Get up, stretch my legs, touch grass a little bit, get some food. Also, yes. But all right, guys. I'm glad. So it looks like Twitch is running good, which is a good thing. I don't know. I remember I was having some issues when I was running Twitch simultaneously. Like it was really killing my my processing power. So I'm glad. But then again, I was also playing a high intensity game and not like Battlebit, which like my mobile phone can run. But I might be on later tonight. We'll see. We'll see what the mood brings. I might switch to Skyrim. But as far as the GPUs goes, I don't know. The guy at the shop ran benchmark after benchmark. He ran benchmark several times. He played COD on with the card on his rig, and there was no blue screen of death. Nothing. So I don't know. I don't know. It might be the power supply, which would be annoying because this should be a brand new power supply, but we'll see. All right. Talk to you guys later. Have a good one. See ya.